Hello friends, welcome to Learning Sessions, and in this video we are going to talk about the very important concepts related to the CAIIB. If you have not subscribed to our channel yet, do subscribe the channel at the earliest and press the bell notification icon so that you get updated whensoever we upload the new videos over there. And let me tell you one thing, if you want to get the free PDFs for the CAIIB, in that case particularly visit the link that is available on the screen right now. And also you can actually be downloading the PDFs. Just WhatsApp us writing #CAIIB PDF and WhatsApp it to the number 83609444207 and we will be sharing the free PDFs link to you. So do hurry up and do join the courses, and that will be related to this. So do watch this video till end because this is actually a game changer video for you.
Next, it is regarding the Bankers Book Evidence Act. Bankers Book Evidence Act. First of all, we need to understand what does Bankers Book consist of. So it includes the ledgers, day books, cash book, account books, and all the other records which are used in the ordinary business of the bank. So these could be ledgers, these could be day book, it could be cash book, cash memo, account books. Each and everything it is covered in the Bankers Book. And further, whether these documents are kept in written form or those may be stored in a microfilm or magnetic tape, because after the computerization it could be that there is electronic data retrieval mechanism, or it could be mechanical data retrieval mechanism, or it could be in the register form, or it could be in the electronic form, we want to say. Okay, and further, either on site, the data could be either available on site. On site means the branch is working in area A. And if the data is placed in the same location, it is said to be on site. But if centralized database is being maintained at some other position, that is said to be off site. Okay, so the data could be maintained either off site or on site, including a backup or a disaster recovery or both. Okay, so disaster recovery site is what? So it says if a branch is working at location A and its server is being maintained at place B, it could be the case that a recovery backup is being created at some other position. That is a disaster recovery database. That is a disaster recovery site or disaster recovery database that is being maintained. Okay, that could also be the case. So it includes all those records which are being maintained, whether those are offline, whether those are electronic form, whether those are mechanical retrieval, whether there is electronic retrieval, whether these are on site, whether these are off site. Okay, and further, it is regarding the certified copy. If maintained in the written form, if the books of the bank are maintained in the written form, a copy of any entry in such books, together with a certificate written at the foot of such copy mentioning that it is a true copy of that entry. So what do you mean by certified copy? When an entry is in the written form, a copy of that entry is taken. At the bottom of that entry, that entry or in the footnotes, there is mentioning that it is true copy. It is certified that it is a true copy of such entry, and further, that such entry is obtained in one of the ordinary books of the bank. That if the entry that belongs to the cash book is to be copied, then it will be copied over over a page. And in the footnotes it would be certified that it is a true copy of such entry, first of all. Second, it is regarding such entry has been contained in one of the ordinary books, in case we are considering it to be the cash book. And further, that such entry was made in ordinary course of business. It means this entry was existing over there as per the ordinary course of businesses and not made specially. And further, that such book is still in the custody of the bank. So that is the certification that you require to mention, that is to be certified. And further, if the copy has been obtained by a mechanical process or by electronic means, in that case a further certification to that is required. So if the entry has been copied as such from the system, in that case it is to be certified, first of all, that it is a true copy and it is contains in one of the ordinary books, and the entry has been made during the ordinary course of business, and such book is still in the custody of the bank. And further, if it is obtained by a mechanical mean or some other process, then it should be ensured regarding the accuracy of the copy, that while retrieval the requisitions were followed. Okay, so that is regarding it. So further certification in that regard is required. So what if it is maintained in electronic form? then it could consist of printouts of data that is stored in floppy disk tape or any diskette or electronic magnetic data or maybe a pen drive, a copy of such printout, and it should contain the certificate. So if there is electronic data retrieval, then the entry or the data that we want to retrieve must be stored on some electronic media, must be stored on some electromagnetic storage device, and the printout of such data is to be taken out. And further, a copy of such printout should be certified, which will be having all the applicable contents as we mentioned above. So all these things must be certified on that copy. And further, if it is maintained in mechanical form, if the data is maintained in mechanical form, in that case a printout of any entry in the books of a bank stored in a microfilm, magnetic tape or other form of mechanical or electronic data retrieval mechanism obtained by mechanical or other process, and it should contain a certificate that have all the applicable contents detailed above. So whether it is an electronic retrieval or it is a mechanical retrieval, a special certificate is to be held along with the printouts. Okay, that is the case. Then it is regarding legal proceedings under the Bankers Book Evidence Act. Includes the following. It includes the following. So any proceedings or inquiry in which evidence is or may be given an arbitration. It could be the case that there is a dispute between two parties, and for the resolution of the same it could be that the documents are required. And further, it could be an investigation or inquiry under the CPC, that is Code of Criminal Procedure, and it could be under any other law for the time being in force for the collection of evidence. It could be the need that the data is to be collected from the bank itself, because the data from the bank, that the banker book are prima facie evidences. These are taken as prima facie evidences. And further, it could be the case that these are required under an arbitration, it could be required under an investigation under the CPC, or it could be under any law which is time being in force for collection of the evidence. And it could be the case that the investigation is being done by the police officer or by any other person not being the magistrate authorized on behalf of a magistrate. Okay, authorized on behalf of a magistrate or by any other law for the time being in force. Okay, due to which the investigation of the document is to be done. So certified copy of entries from the books of account is valid primary evidence. So certified copy that is taken whether through the mechanical retrieval process or through the electronic retrieval process, the certified copy is a prima facie evidence, is a primary evidence that can be considered. Okay, but it has the same value as that of the original entry. It is as much worth as that of the original entries. Okay, but further, by virtue of duly certified statement of account, the evidence of the amount due will be accepted actually by the court. The amount due will be accepted actually by the court, and court may pass a decree in favor of a bank. The court may pass a decree in favor of a bank. What does it mean? It means if bank has sued person A that there is a due amount against person A, if there is due amount against person A, in that case banks may need to produce the documents in the same regard. In the same regard, if the books are placed, if a certified copy is placed before the court, that would be considered a primary evidence. That would be considered as a primary evidence, and based upon that primary evidence, the court may basically pass a decree in favor of the bank unless a particular entry is challenged. If there was some entries regarding rupees 1 lakh or 2 lakh, and person A which has been sued in the court says that these entries are not have been done by me. These entries have not been done by me. In that case, those have to be proven correct. Okay. Otherwise, the court consider those entries. All entries. And further, when the bank cannot be compelled to produce book, when no officer of bank shall in any proceedings to which bank is not a party. Okay, so in any of the legal proceedings where bank is not a party, the bank or any of the officer cannot be compelled to produce the banker's book, cannot be compelled to produce the banker's book, the contents of which can be proved under this act. Okay, so if bank is party, in that case bank has the obligation to produce the book, but in case the bank is not a party, in that case bank is not compelled to produce the book or to appear as a witness to prove the matters or transactions. Okay, further, the magistrate may make an order under section 94 of the CPC for production of the original documents by a bank. The magistrate may make an order under section 94 of the CPC for production of the original documents of the bank, but the bank producing the documents, bank may also object to its inspection. So we can say if magistrate M is here and magistrate orders over here for inspection of the original documents, and bank B makes an objection to it. It may be the case that bank can produce the documents, or it may be the case that bank can raise an objection, Okay, the bank producing the documents may project to its inspection as per this text. So as per the Bankers Book Evidence Act, the bank may raise an objection to the orders of the magistrate, because Bankers Book Evidence Act is a special act and CPC does not affect its validity. And further, an order of the court for inspection of the books of the accounts of banks cannot be made without hearing the bank. The order from the court for inspection of books, if a court has ordered regarding the inspection of the original documents, that inspection order cannot be made without hearing the bank, and if it is done so, in that case bank is not compelled to follow the orders. Okay, so these were the three conditions. First of all, where the bank is not party, and further the orders have been made by the magistrate to produce the original documents. In that case, bank can raise an objection to it, and further, an order of the court for inspection of the books of accounts cannot be made without hearing the bank. Then regarding the conditions in the printout, when the books of the banks are not handwritten and copies are taken by way of printout. So in the electronic media or electromagnetic media, the printouts are taken from the system itself. Then in that regard, a certificate by the principal accountant or the manager to the effect that the printout of such entry or such printout, and regarding the certificate by a person in charge of the computer system containing a brief description of the computer system and particular thereof. So certificate is to be obtained by the principal accountant or manager, or a certificate is to be obtained by a person in charge of the computer system. Okay, so whoever is a person in charge of the computer system and whoever is the principal accountant or manager, a certificate from them is to be obtained in the case of the printouts. So whenever a printout is to be presented as an evidence, in that case a certificate is to be obtained. Okay, and further, this certificate is regarding, first of all, that all the safeguards have been adopted by the system to ensure that the data entry that has been made and the operations obtained on that particular entry are only by the authorized person, that it is the only principal accountant or only the manager who has entered the data, okay, and none other than have performed that function. First of all, it is regarding the safeguards adopted by the system. Then it is regarding safeguards adopted to prevent and detect unauthorized of data, that the data integrity is maintained. It is not like that the data was stored in the electromagnetic device and it could be the case that it has been amended. So it is to be certified that all the safeguards have been adopted to prevent and to detect the unauthorized change of the data. Further, it is we need to certify regarding the safeguards available to retrieve the data, that at the time of retrieval of data, the data is retrieved in such a way that there is no loss of data. And further, the manner in which the data is transferred from the system to the removable media, the safeguards have been adhered to. The safeguards have been adhered to when there was transfer of the data in the network. And further, the mode of verification in order to ensure that the data has been accurately transferred to such removable media, this is to be certified. And further, the mode of identification of such data storage device, the arrangement for the storage and the custody of such storage devices. Okay, that there was particular arrangement of the storage and the electromagnetic device in which the data is stored is under the custody. And further, safeguards to prevent the detect any tampering with the system, that is that there is no tampering with the system. And further, that any other factor which will vouch for the integrity and accuracy of the system have been taken care of. Okay, so we meant to say that all the safeguards have been adopted, whether it is regarding the authorized entry, whether it is regarding the retrieval, whether it is regarding the storage, whether it is regarding the transfer of the data, whether it is regarding the custody of the electromagnetic devices. All the safeguards have been taken care of, and this is to be certified whenever it is a case regarding the printouts. Okay. Then it is regarding a further certificate is required from the person in charge of the computer system to effect that to best of his knowledge and belief such computer system is operated at the material time he was provided with all the relevant data and the printout in the question present represents correctly and is appropriately driven from the relevant data. Okay, and further certification from the person in charge is required regarding it. Okay. Then it is regarding mode of proof of certain entries in banker's book. Mode of proof of certain entries in banker's book. A certified copy of any entry in banker's book shall in all the illegal proceedings be received as prima facie evidence of the existing such entry. Okay, so a certified copy is considered to be as an prima facie evidence of the existence of such an entry, and it shall be admissible as evidence of all the matters, transactions and accounts therein recorded in every case as of the original entry itself. So we have already read that a certified copy is considered to be as good as that of the original entry itself. And to make a person liable, mere entry of the books are not sufficient. If we say in the books of the account there is a debit entry of rupees 50,000, there is a debit entry of rupees 50,000, and this is under the account of person A, and person A says over here that he has not withdrawn this particular amount, and then in that case just to produce such entry under the Bankers Book Evidence Act would not make the person A liable that he has made such entry, Further proof in that regard is to be submitted. That the entry has been performed by. So there must be some voucher regarding it, withdrawal voucher regarding it, or some entry regarding it to make sure to make him liable. Okay. Then it is regarding inspection of books by order of court. On application by any party to the legal proceeding, the court or judge may order that. If an application has been submitted by any party on the legal proceedings, the judge or court may order such a party may be at the liberty to inspect and take copies of any entries in banker's book for any of the purposes of the proceedings. So if the court or judge finds it fit that it is required under the legal proceedings that the party should be having the liberty to inspect the books and further to take the copies of such an entry, it can be ordered in such a manner. And further, over there the bank is having the liability so as to prepare and to produce the books within the prescribed manner of order, and certified copies of such all entries must be further accompanied by a certificate that none of the entries are found in the books. If such entries are not found, and in that case it should be accompanied by a certificate that no other entries are found in the books of the bank relevant to the matters in issue of such proceeding. So if it was required by the court that all the related entries to person A must be furnished. In that case the entries will be furnished, and further it would be certified accordingly as we read above, and further it would be accompanied by a further certificate that no other entries are found in the books of the bank relevant to that particular matter. Okay, and this particular certificate that is issued, it should be dated and signed as required for certified copy. Okay, then it is regarding an order that bank officer should either produce the books of accounts or appear as witness, can be made by court or judge with or without summoning the bank. It could be the case that an order has been made by the judge or by the court regarding that either the bank should be producing the books of account or the bank should be appearing as witness, and it could be with or without summoning the bank. The order so passed shall be served on the bank at least 3 working clear days before the same is to be obeyed. Okay, so if the order is to be obeyed by the bank, the order must be served on the bank at least 3 clear days, means 3 working days period must be there before the order is to be obeyed. And further, the bank may at any time before the time limited for compliance of any such order to produce the books at the trial or give notice of their intention to show cause against the order. Okay, so if the bank wants to produce the books, it is bank can. If the bank wants to produce the books, bank can, but bank can also raise an objection. Bank can also raise an objection against the court order, or judge order to show cause against the order, and in case the bank chooses to give show cause against the order, then the order passed by the court or judge cannot be enforced without further order. In that case, the order further prior passed by the court or judge cannot be enforced without further order. Okay, so I just told you that it could be the case that court may have ordered the bank either to produce books, the books of accounts, or to appear the bank as witness. Such an order, if it is to be obeyed, should be served on the bank 3 working days prior to the order to be the bank to be witnessed. 3 days prior to the bank to be witnessed. And further, regarding the compliance, if the bank wants to obey the order, bank can do so. Bank can produce the books or bank can appear as witness. But in case the bank can also raise an objection. Bank can also raise an objection to show cause notice, to show cause against the order. Okay, and further, in the case if bank chooses to give show cause against the order, then the order passed by the court or judge cannot be enforced without further order. Okay, that is the case. Next it is regarding the law of limitation 1963. So what is limitation period? First of all, limitation period is a time limit during which the parties to a legal agreement can take an action in a court of law to enforce their legal right. So what it is, so if there was a agreement, there was a contract between parties A and B, and there were some conditions and terms and conditions which were to be followed. So there must be some rights of A, and further there must be some duties of B. Okay, if A is the lender, B is the debtor, there must be some duties and there must be some rights. Okay, and further, limitation period is that time period during which the parties to a legal agreement can take action in the court of law to enforce their legal rights. So whatever rights are mentioned there in the agreement can be enforced in the court of law during that particular time period, called as limitation period. Okay, and if the limitation period is expired, the parties are barred only from filing the suit. And further, the right to recover the debt is not taken away by the expiry of limitation. Okay, so if bank has granted a loan to person B and the limitation expired, it means that A cannot go for legal remedy against person B, but in case there is some recovery in account of A has every right to recover the amount, as we read in the case of right of set off, as in the case of pledge. Okay, the limitation, even if it is barred, the bank has the right to exercise the right for its recovery. Then limitation period cannot be shortened or lengthened by mutual agreement. It cannot be the case that it is mentioned as a condition in the agreement itself that the limitation will never be expired. It cannot be done in that way. Okay, so limitation period cannot be shortened or cannot be lengthened by mutual agreement. Then it is regarding period to be excluded for computation of limitation. Period that is to be excluded for computation of the limitation. So while calculating the expiry date of limitation period, which period is to be excluded? It is as per the options given below. So first of all, it is regarding closure of the court. It means if the limitation period is expiring on the day when the court is closed, it could be the case that the limitation expires on 26th of January or on any other day when it is public holiday or the court is closed. In that case, the suit can be filed on the day when the court reopens. Okay, it means the closure date when the limitation expires can be excluded and the limitation will be available till the court when it opens. Okay, then it is regarding absence from India. So such any period during which the borrower was absent from India, that will be excluded from the limitation period. What does it mean? If the loan was sanctioned and disbursed in 2018, and as per a standard rule, the limitation over there in the case of bank loan is available for 3 years. So it is available up to 2021. Let us say the case was sanctioned in January and the limitation will be available to January 2021, and the borrower was absent from India for a period of 1 year. In that case, this particular period during which the borrower was absent from India can be excluded, and further the proper documentation in that regard is required. Okay, then it is regarding injunction. That says if a person is restrained by way of injunction from the court, if there is an order, if there is an injunction from the court that a person is restrained to enforce a legal remedy against, that no legal remedy can be against such person for some specific period, so such specific period is to be excluded from calculation of the limitation period. Okay, if a court has made some order that person is restrained by way of injunction, person is restrained to enforce a legal remedy against him, in that case such particular period is to be excluded. Then the fourth case, it could be regarding the court jurisdiction. When the court in which suit was filed, it was filed in a wrong court inadvertently. So inadvertently the suit was filed in the wrong court, but in the good faith. In that case, the time which was consumed in such proceedings, can be excluded for the calculation of the limitation period. It means if the court case was to be filed with court A, but it was wrongly filed with court B inadvertently, and further the time period which was consumed in this court, that can be excluded from the limitation period for the calculations. Okay. Further, the limitation period, how it can be extended? It can be extended by way of acknowledgement. Letter, which we say balance confirmation letter or acknowledgement of the debt due. Okay, so the limitation period can be extended by such manner. Further, even after expiry of the limitation period, the liability can be enforced if there is a fresh promise to pay. It means once the limitation period is expired, it cannot be extended by means of acknowledgement, but a fresh promise is to be paid, that a fresh agreement is to be signed for the limitation against the guarantor. So limitation against the guarantor will begin only and only when the demand is made on the guarantor. When the demand is made on the guarantor and the guarantee is involved, the limitation period for guarantor will begin from that particular date. Okay. So here are given the limitation periods for different instruments, you can say, different kind of loans, you can say. So in case of demand loan, in case of term loan, in case of demand bill, in case of dishonored usance bill, the limitation period is 3 years. Limitation period is 3 years. And the date of limitation in case of demand loan, term loan, and from the demand in the case of demand bill, this will begin from the date of loan made, date of loan disbursed, or in case of term loan, it will be from the due date of each installment. From the due date of each installment. And in case of demand bill, it is from the date of the bill. And in the case of usance bill, what does usance bill says? Usance bill says that the payment is to be made in future on some particular date. Okay, that is a usance bill. In that case, if it is dishonored, the limitation period will be starting from the due date. The limitation period will be starting from the due date. And further, in case of cash credit, it is 3 years, and it is 3 years from the date of document. In case of cash credit, it is 3 years from the date of document where the hypothecation charge is being created. And once the when the charge is pledged, in that case, we have already learned that no limitation period is there, because in case of pledge, the possession of the goods is already with the creditor. The possession of the goods is already with the creditor. And further, by a mortgage, for the right of foreclosure, for the right of redemption, the limitation period is 30 years. Limitation period is 30 years. And for possession of immovable property mortgaged by the mortgage, in case of possession of the property, in case of mortgage by the bank, in that case it is 12 years. So do not misunderstood it. In case of mortgage, the limitation is 12 years, but for the right of redemption and right of foreclosure, the limitation is 30 years. And this 12-year period will start from the date when the mortgage money has become due. This 12-year period will start from the date the mortgage money has become due. Okay. Then it is regarding fixed deposit, it is 3 years. For fixed deposit, it is 3 years after the date of presentation for the payment by the depositor. After the date of presentation for payment by the depositor, if the payment is not made, the case can be filed within a period of 3 years. Okay, when the FDR is presented, for the payment. Okay, and in case of fraud, it is 3 years from the date of fraud is detected. It is 3 years from the date the fraud is detected. Okay. And further, if for any of the particular application, if there is no limitation period mentioned in the Limitation Act, that would be deemed to be 3 years. That will be deemed to be 3 years.
So I hope that you must have liked the content of the video. So if you have liked the content of the videos, do give it a thumbs up, and further, do share the video among your friends and colleagues who have been preparing for CAIIB, and do not basically miss the course which is actually available. It's actually a pro course and you need not to go through anything else other than this particular course over there. So do hurry up and enroll in the course right now and start preparing for the same.